One thing that would reduce the amount would be if it's not clear that something was negligence. Now, we all know of cases where you have an amputation of the wrong limb. So there are cases where the mistake is clear. It's not up for debate or discussion. But more often than not, that's one of the elements that's argued.
Life's Third Act is a podcast dedicated to helping you get the most out of your retirement. Sponsored by Tucker Allen. Here's attorney CPA Joe Cordell.
Welcome to another episode of Life's Third Act. Today we're picking up with part 2 of the life, legacy, and estate of Maurice Gibb. If you've not seen part 1, it's probably a good idea to do that, though it's not completely necessary. In any case, I hope you enjoy this episode. So let's talk then about this death and what it might mean financially to the estate. Maurice was 53 years old. That's young. He had a lot of earning years ahead of him. He had projects ahead of him that were scheduled to be completed. He had additional songs that would have been written, performances that would have been performed. There were endorsement deals that were not available as far as he's concerned because of this. So there were a lot of things that were impacted by his death. So whenever someone dies and another person, a family member, or more often than not, the personal representative in the estate in technical terms, because it's really the estate, which is like the person suing for his own death. So most of the damages are often awarded to the estate. So in this case, the personal representative of the estate, which was a lawyer that represented Yvonne, I think that her name was Femina, Rose La Femina. She was the personal administrator of the will. So whoever that is, that's the person who technically brings the suit. But in reality, it's the family. It's the family who's bringing it. And they're alleging that this death was caused by negligence, that there was a duty to perform these services correctly, and that as a consequence of that breach of duty, that there was harm done. And then it's called damages. Then there's a matter of what are the amount of the damages. So let's think about the elements of a personal injury cause of action. On the one hand, there has to be the duty. In other words, if somebody doesn't owe you a duty, the fact that they screw something up and you get hurt, that doesn't give necessarily someone a cause of action. But when there's a duty, as there always is when you're in the care of a medical provider, and there's a breach of the duty, and we'll talk about that in just a second. If there's a breach of the duty, which would mean something like negligence, and there's harm, then that means that you can say, well, how much is the harm? Let's calculate the damages. I want to be paid for that damage, the amount of that harm. So whether or not there's a breach of duty means, was there an intentional act, could be intentional, or was it negligent? Well, what in a typical run-of-the-mill personal injury case, we're always talking about negligence. Rarely are we talking about what we call an intentional tort. That's where somebody comes up to you and punches you in the nose. They had a duty to allow you to peacefully engage in whatever you engaged in, and then when they punch you in the nose, obviously that's a breach and it's intentional. So in this case, in medical malpractice cases, it's always 99.9% negligence. So was there negligence? It's not enough that you show there's a harm. Let me make this clear. Medical provider have a duty, and you can have a harm pretty easily, meaning somebody doesn't get the outcome they thought. They go in, expect to come out healthy, and they end up dead on the operating table. Or choose your own example. So there's lots of examples where people don't get the outcome they wanted, a bad result, a harm from this relationship. But it doesn't mean that there was a breach of duty, which requires something like negligence or intentional. So if these elements are met, though, if you have a duty, if there's a harm, there's negligence, then you say, well, are there damages? And then if there are damages, then you calculate what those are. We don't know how much was paid by the medical providers to Maurice's family. We do strongly suspect there was a big payment made. Here's the facts we know. Within days, virtually, of Maurice's death, his other two brothers were both saying, Robin and Barry were both saying, this shouldn't have happened. This was, there was something wrong in the services or the care provided by Mount Sinai Medical Center, which was in Miami, I think. It's Miami, Florida. So as time went on, we found out that their allegation was based on the idea that Barry, during this surgery, he was undergoing, we talked about the blockage, that the purpose of the surgery was to fix that. Apparently, he had this heart attack and he stopped breathing, which is common in a severe heart attack. So there was not the medical equipment available in the surgery room, in the operating room, to provide him, to be able to return him to breathing immediately. So again, I don't know all this is fact. Let me tell you, when you have discussions like this going on between the lawyers and the family, you rely on what's been leaked. And so these details may or may not have been correct, but if you want to research this, you'll find a number of sources cite this series of events. So all I can say to you is I wasn't sitting in the room when the family members confronted the doctors, when the family members' experts talked to the doctors. We know, or I'm pretty sure, there was no lawsuit actually filed. I didn't see a lawsuit filed. And I think it was because of Yvonne. Yvonne did not want this to become an ugly lawsuit. I think that Barry and Robin were so PO'd over this and so angry that my understanding is that they were arguing and threatening to sue. But the ultimate decision, because the beneficiary of any lawsuit primarily is going to be Yvonne. And she felt that she did not want a lawsuit if it could be at all avoided. So I don't think there was anything filed. I think that her approach was to sit down with the representatives of the healthcare providers and negotiate a settlement. Now, in an instance where there's medical malpractice like this, usually there's more than one defendant. So the likely defendants, had a lawsuit been filed, or the defendants typically in such cases would include the surgeon, would include the anesthesiologist, would include the hospital. And then if there were any equipment involved that failed or supplies or other things, then it could be against a manufacturer in the background. But in this case, I don't think that's relevant. So I'm guessing that there were probably negotiations with representatives from all three of those groups. It sounds like most of the liability, though, would fall on the hospital. But again, I'm speculating. It could have been that the anesthesiologist was the one whose primary obligation was to assure that was in the room and available. And without knowing more to tell, we can speculate that looks like an oversight. So we know that there was an agreement reached, and that, again, it's not published anywhere. This is strictly on what has been reported through leaks. But I find it very believable that Mount Sinai would want to avoid really bad publicity, especially one of where the victim is very beloved worldwide. And this medical facility in Miami has a great reputation otherwise. So I suspect that they really wanted to avoid the lawsuit. And it's not that Yvonne, I'm sure Yvonne would have filed a lawsuit, but what was reported was she put her foot down to the brothers and said, I want to resolve this out of court. Sometimes, incidentally, I should point this out, sometimes you end up with a better deal before you file than after you file. I think the brothers' attitude was, let's document this, let's put it before the public, let's put it in the court, file these pleadings, make our specific allegations, and then, we'll let it get down the road, and over time we'll likely reach a settlement before it ever goes to trial, and that's going to produce the largest settlement and the most, responsibility, being held most responsible for these wrongdoers from the standpoint of the brothers. And because they didn't have a financial interest, I don't think they would have again, I'm not a personal injury lawyer. I don't think they would have a financial interest in this malpractice claim. But anyway, so what do we think was this likely payment? Let me tell you a little more about the things that might have been involved in negotiating a settlement for damages for somebody such as Maurice. As I mentioned to you, Maurice, he's healthy otherwise. He has years to go of providing music, entertaining, recording, sponsoring. There may be other projects in which he participates. Whenever the Bee Gees were not traveling or were not recording, he would find things to do in these projects, and often they were projects relating to recording with other bands. And again, not necessarily his performing with them, but his playing a role in deciding how the song should be structured and arranged, and that ultimately, to be honest with you, creates very often the identifying sound of the song, more so oddly enough than the tunes and lyrics. In some cases, obviously tune and lyrics are the most dominant thing for most songs, but we all know songs that's really the arrangement we remember. So putting ourselves in the position of an imaginary judge, which is what the healthcare providers would have done, as well as Yvonne and her attorney would have done, would have been, what are the fair and reasonable damages? And I'm going to suggest to you that when you consider all those factors I mentioned, and some that, of course, none of us know about, which probably were mentioned, yeah, you could easily have been talking many millions. It's just hard to say. But I suspect, and I'm guessing, I don't know, I suspect that this would be north of $10 million easily. But we don't know. We don't know. But at least I want you to understand that when you have harm that comes to a prominent performer, the way you calculate damages, if it destroys their career, obviously if they're dead, but I mean, even if, like with Barbra Streisand, she had a surgery that impaired her vocal cords. I don't know what that settlement was, and I don't know if that was reported even. But in any case, you can imagine that was a lot of money, because even though she wasn't 21 years old when it happened, she still had a career ahead of her. So again, we don't know the amount of money that was involved here with Maurice Gibb's death, but I suspect it's a substantial amount. And regarding, let me come back though to what I think is a key issue here. One thing that would reduce the amount would be if it's not clear, as it often is not clear, that something was negligence. Now, we all know of cases where you have an amputation of the wrong limb. I mean, so there are cases where the mistake is clear. It's not up for debate or discussion. That's true maybe 30% of personal injury or medical malpractice cases, we'll say. Maybe 30%, maybe 35%. But more often than not, that's one of the elements that's argued. It's not as if you go to trial and you go immediately to talking about the subject of, okay, how do we calculate damages? Sometimes the focus of the trial won't even be on that subject. It'll be on whether or not there was negligence. In this case, the hospital may have said, look, it wouldn't have made a difference if this piece of equipment were there, or they may allege that it didn't really take 10 minutes. The argument is that there was a 10-minute delay getting this piece of equipment into OR, and that during that 10 minutes, oxygen was cut off, and that it did irreparable brain damage to Maurice. That was the argument. So the hospital may very well, I suspect, would have said in these negotiations, well, we have an expert who's going to say that even if this equipment had been there, it wouldn't have made any difference. Or they may say the equipment was in fact nearby, and the people, the anesthesiologist should have known where to go. So the reason it didn't get there soon enough was the anesthesiologist, sent people to the wrong place. You know what I'm saying? So let's assume, though, we get past that and we end up focusing on damages. And what happens then is the damages get discounted for the uncertainty relating to that. So if there's a 75% chance that there was negligence, then I'm not saying someone will have a calculator doing this math, although they may. It's not unusual. But I want you to understand the concept. The concept is the degree of uncertainty about negligence, which means causation of the injury. If there's whatever degree of doubt there is the amount you would discount actual damages. So if you came up with $100 million damages, but there's a 30% chance that maybe there wasn't any negligence, then you're down to $70 million. I'm not suggesting those numbers for this case, but I do think this case could very well have settled above $10 million, but we just don't know. We don't know. So that I wanted to talk about that because that's a big asset when we talk about the estate, and we don't know where that went or what happened. Incidentally, other causes of damages would be pain and suffering, which is different from the economic costs. Another might be where, a surviving spouse would have her own action, for what's called loss of consortium or loss of relationship. That can also be a separate cause of action because it is separate from that person's loss. And then the economic consequences to other individuals, although often that's redundant because whatever the economic loss of this provider, of the person who died, if they're a provider, then that's going to that essentially is money that would have ended up supporting the family. So, but the loss of consortium, pain and suffering, those things are kind of non-economic damages and can often be added to the amount that would otherwise be recoverable. So let's go to one other thing when we talk about the estate of Maurice, is that there was some question raised as we were looking at this among us really as to, what about the intellectual property that we've talked about so often on this show? And just a little bit of a review here. I kind of made a list where I want to talk a little bit about each of these components. It's not complicated, at least to understand the idea. It gets complicated in the application to one particular case or another. But when you think of royalties, think of it along kind of this continuum of 6 forms. So you can say mechanical royalties. That's kind of what's generated anytime you think of a record that's made or any sort of, even a recording digital, actually, they've amended this definition of mechanical royalties to include digital recordings. So anytime something's made for mass reproduction, that's going to be called mechanical royalties. So just transport yourself back or imagine yourself in the 50s, and when you talked about mechanical royalties, everybody would understand that phrase. So that's really the definition today, except it includes the same concept, but it's digital. Performance royalties, I don't think that requires any definition, but any time that a song is performed, that's going to be paid. It doesn't mean a live performance. It means a performance is when a radio decides to play a song or when some streaming service decides to stream a song. That's different from selling the mechanical royalties. I don't want to confuse you guys, but do you see that? The mechanical royalties are buying this song that you play anytime you want. You own it. So it used to be a record. Then it was tapes. 8-track tapes. Justin, have you ever heard of an 8-track tape?
Yes. I don't think my family had. We were a vinyl and cassette family. Okay. Not an 8-track family.
Yeah, cassettes were the next permutation of tapes. But then it went to CDs and whatnot. So now yours is like a digital, CD was digital recording, and yet it was imprinted on an object, and now you download it. But you own it, and you get to play it when you want. When you own it, it falls under mechanical royalties. That's what's paid for. So performance royalties means it is a recording, but it's played on a radio station, or someone wants to play it for entertainment to a large group of people, to an audience. It could be international, but they want to play it. And that's a performance royalties that they pay. And then sync royalties are when, like we were talking about a while ago, if you want to use something as a background intro to the show, I think Stayin' Alive would be great for this show, for Life's Third Act. So we are going to look into that, aren't we, Justin? Okay, so when you talk about sync royalties, that's kind of what you're talking about. You're not playing it for the public to just enjoy. You're not buying it to use for your own listening pleasure. You're using it just as an intro for your show, or on a TV show, people will play it in the background for something. Commercials are huge. So sync royalties. And then there's this thing called digital performance royalties. This is a category that was developed to deal with what do you do when you're cutting deals with not just radio stations, not terrestrial radio, but rather with satellite radio, for example, with Sirius. And there was XM. I guess they've merged, but there'll be others. And it's really a different category because there's a price for a radio station to play a song, and those are standard prices. So there's not discrimination. Every deal is not negotiated separately, et cetera. But what if you are a station that wants to have the right to play stuff whenever you want? This concept didn't exist before this century. It's always, you want to play it, when you play the song, you pay us. But the idea that you obtain the right to play something or stream something whenever you want, and this probably applies to some of the stuff that we listen to in terms of, what do you use, Pandora, or do you use Spotify? Spotify is now I think their numbers are bigger than Pandora.
I think so.
So this might apply to them too. So whenever you're playing a song that's going to be heard across the planet, how do you charge that? You don't charge it like you would a radio station. It's different. And especially if you have the right to do it at times of your choosing. So that just brought in a whole new question for how you do pricing. And it ended up with these prices per month, that they pay, something that the music industry had never confronted before. And and there's still a brouhaha among artists. Many argue they're earning less money now than they did by these quantity deals that are done. It's just a new era. The world has dramatically changed. And so that is what's included in the category of digital performance royalties. I should also mention there are print royalties still. There's music printed. And, whenever you sell the music in a printed form, and probably would even include a digital form of just not playing the music. Remember, that's separate. But just to look at the music, reading the printed music, for lack of a better word. Yeah, I have to say printed even when it's digital. So that's a different category of royalties. It's called print royalties. And then finally, there's the master recording royalties. That's whoever owns that original right, whoever made the original recording, like often Columbia, Capitol, they own that master. And that master is a different subject. So every time something's played, whatever you pay to other people, these other things, you also pay a portion to whoever owns that original master. Many of you who followed Taylor Swift, you need to follow to some extent, this major, what would we call it? This major war between who's the guy that ended up owning 6 of her albums. Her first 6 albums were made. They were with a recording company that didn't cooperate with her. Remember, she was a child at the time. So first 6 albums, they were all huge. And as she became more and more famous, they became, for lack of a better word, huger and huger. So these albums were worth a lot of money. Well, she wanted to buy the master recording royalties. And that meant that she would have control of those masters and could do with them what she wanted. And that affects anybody. And all these others are really derivative of these masters. If you got rid of the masters, you'd still have some of this stuff because when people perform your music, et cetera. But that original recording of the hit, that's what the master is, that original recording. So who is the guy that became her nemesis?
Scooter Braun. I could tell you the whole lore about it if you need me to.
Oh, you're an expert on this.
I love Taylor Swift. I see her next weekend, so.
Well, my daughters have seen her 2 or 3 times. So, and I know our audience might think we're taking them off of the beaten path here. Let's just take a couple minutes and talk about this. And again, the purpose of talking about this is to really demonstrate how royalties work. And those of you who are interested in knowing, the estates of celebrities, the estates of artists, then it really helps. And it's kind of fun to know how royalties work because that is really the foundation of the wealth of the vast majority of artists in the world. So let's take just a few minutes. Tell us a little bit about this thing with Scooter and how they ran into this disagreement because this illustrates master recording royalties.
Yeah, so basically like what you were talking about, the master is the original recording. Taylor was a child. She was a 15-year-old girl when she first started recording music. They signed with this record company that Scooter Braun manages, owns. He's stepped out of it now.
He's a wealthy guy.
Yes, he is. He works with a lot of other well-known artists like Ariana Grande, Justin Bieber, all of the pop hit artists now. But basically, she was coming up to a point that she no longer worked with him, and her masters were coming up to the point that they could be bought. She was deciding to do that and she wasn't telling anybody about it, but she told one of her close friends or who she thought was her close friend, and her close friend went and told Scooter, and then they helped him purchase the masters.
So he thought he could hold her hostage with this.
Yes. Yeah. Basically, that's what that does. She doesn't technically like own the music. And I know that sounds really weird because you think like, well, that's her music. She sang it. But that's kind of not how it works. And she could only use it like for specific purposes and all kinds of things. And so what she's done now is she was kind of like, okay, well, those are really important to me. And now she's re-recording all of her albums as they come up in like the time frame of like, because there's a time frame of re-recording also with masters that like you can't re-record them within a specific amount of years. But she's re-recording all of her old albums that were purchased by him, the masters were, and she's got like 2 more left, I believe. And then she'll own all of her masters essentially again.
So what this means though is that whenever Scooter Braun purchased these, and he paid a couple $100 million.
Oh yeah, he paid a lot of money for them.
Yeah, so this guy, who again he's a wealthy guy, so he has power and influence. So he buys these. Let's call it $200 million. He buys these master recordings. So what it means is that whenever the song is played from these masters on any of these sources here, whenever the song is played from the master song, then he gets paid. So it does give him some control. Now, don't confuse this with the right to be paid whenever anybody performs the song, also because the writer gets paid. So she didn't give up that. So she still has that copyright royalties. She wrote the song. And some of you are clear on this and some may not be. But that's 2 separate things. So she always held the right to be paid as the author of the song, whoever plays it, whether the recording plays it or whether it's played by some other source. But this master recording is the recording that's played everywhere in the world every day, that original recording. So she's angry because Scooter effectively gets the jump on her and buys these in advance. And she apparently didn't like this guy anyway. Now she really dislikes him. So she did something that, as far as I know, is the first time it's ever been done. She decides that she's going to remake these recordings, new recordings, and that, of course, she'll own those masters. And when she remakes that, she's going to do a better job. She's going to change it up some. She's going to make it clearly a better recording. And once she does that, if radio stations, if people buying this music from music stores or downloading online, wherever they're getting it, if they choose that recording and not the original recording, then Scooter gets nothing. He only gets paid when the original recording is sold or played. Not if it's the same song, but it's recorded, 8 years later, and already I've read the reviews. Taylor Swift, these 6 recordings, the 4 that have already been done, 2 to go, they're superior. I mean, critics are listening to it and saying, this is a more thoughtful, a more mature rendition of the song.
And it's very interesting, too, because she's also releasing vault tracks that he doesn't have any rights to release. So she is making all the money off of those that were originally supposed to be on, the original albums. But she's releasing those along with her re-releases so that she can actually get awards off of them. That's how she's been winning Grammys and everything for some of her older albums as well, because it's a certain number of songs have to be new.
You can't win a Grammy off of an album that you've released already, essentially.
Oh, is that the way it works?
Yeah, so it would have to be kind of a new record.
Yeah.
Basically.
Okay. So. Well, I mean, so you can see here, we've gone down this road to talk about something that I think is interesting, but also I really like to talk about how royalties and intellectual property work on this show, because it's one of the opportunities to, for you to learn about what is, an important asset in the lives of artists, both while they're alive as well as when they're gone. So that's a good illustration of how master recording royalties work. So in this case, as in others that we've talked about, this is a complicated business, and keeping track of the payments for all of these forms of royalties and assuring that they're properly paid is no easy thing. And I think in the world of certainly this century, I think that family members no longer try to manage these. I think that they use professional organizations. And in this case, from what I've been able to glean, is it looks like Barry may be really carrying the ball in many ways for all the BG's families, meaning since we know Robin died in, what was it,
2012.
So 2012, Robin dies. So we have two of them. And I think that Barry, being the big brother, it's interesting that he's the one alive. Normally you'd expect, the older to go first, but he's the one alive. And he is really very much the leader. And I think he played this role to some extent in the lives, maybe resented by Maurice and Robin, perhaps. But still, I think that he tried to be the big brother all along the way. And here in this case, you have, his two brothers are gone. There's family left behind. And it appears that he's the one who has the direct relationship with the firm that's managing these. There are a couple of companies that do this, and a name that we've seen before on this show is Universal Music Group. So the Bee Gees' music, while they were alive, was to some extent managed by Capitol Records, primarily Capitol Records in their later years. And then Capitol Records, I think, was acquired by Universal Music Group. But even if it wasn't, Universal Music Group really focuses on managing royalty interests for artists. That's kind of their thing. And they even extend it to endorsements and brand and likeness and image. This is separate from royalties, remember. Royalties are what we've been talking about, but we didn't spend time to talk about those things, where you get paid to lend your name or your identity or your brand to a product or service. And for many artists, after they're gone, if they were big during their lifetime, there's going to be lots of name and likeness revenues for the next 3, 4, 5 decades to come. So in this case, you need somebody to manage, ideally in the same place, all those forms of compensation and called intellectual property, all those forms of intellectual property, not just royalties, and royalties in their various forms, but also those things that relate to brand, likeness, and identity. A lot of money, more money maybe in the latter category than the former. It's hard to say, but they both, if they're managed correctly, can live on for a long time. And in this case, we have Barry, who I think, this is just, again, I don't have an official declaration by Barry that this is what he does, but looking at the sources we did, he appears to be the one who communicates primarily with Universal Music Group, and he's assigned Universal Music Group to manage all the forms of intellectual property relating to the Bee Gees, and they're overseen by Barry. I think that Barry is the one who, because he has the experience, I mean, what a marvelous opportunity, a marvelous benefit for any surviving family members, children as well, of Robin or Maurice, is that Barry, he's done this. And he's done it for his whole life, really, since he's a kid. He's managed, to a great extent, their careers. And I'm sure Robin and Maurice would dispute that he played that large a role. But my impression is that he did. So now he's in a position where a lot depends on the memory of the Bee Gees in the public's mind, as well as the revenues that are going to flow from that. And I think that he's the one who's managing that. It's a huge help, if so, with Yvonne and the family members also of Robin. So I think that probably the planning in this case was as good as you could have hoped for. It wasn't perfect, but I like to see people who plan their lives well, especially when they come out of this drug and alcohol spiral that gripped him and other family members. Maybe it's a family gene. I hear there are such genes. And yet he pulls himself out of it. He rights the ship. I'm sure there was some economic toll during that period of time, but the bottom line is he pulled his life together, and he he didn't have a series of divorces and the sort of legal actions of a different nature that might flow from drug and alcohol, which we see in the lives of a lot of artists. In his case, he managed to hang on to his fortune to a great extent. He had one divorce early on, so there was a halving that takes place, but that was very early in his career. Later on, he has this huge success with the disco era and thereafter. So he's able to accumulate a great estate that isn't penalized or wasted by some of the decisions relating to, the torrid lives of the rich and famous. So I think he handled his life pretty well and is to be commended for that. I'm impressed with the fact he did his estate planning early and by all accounts did it well. And I suspect now, certainly as long as Barry continues to live and the intellectual property remains in the hands of professionals, that the descendants of the Bee Gees will continue to prosper. So with that, I hope you found this interesting. This has been another episode of Life's Third Act. Till next time, take care.
You've been listening to Life's Third Act, a podcast for thriving in retirement, sponsored by Tucker Allen, your estate and elder law advisors. Each week, we discuss topics and answer questions to help you better plan for your future. For more information, visit tuckerallen.com. Subscribe and listen again next week for another edition of Life's Third Act. The choice of a lawyer is an important decision and should not be based solely on advertisements.